Hi, I'm Rob Carolina. This is one part of a multi-part introduction to the Law and Regulation Knowledge Area of CyBOK. The Law and Regulation Knowledge Area is one of 19 knowledge areas in the entire project. The webinar that introduces this knowledge area is pretty long, and so I decided to break it up into 15 constituent parts. You are now about to listen to one of those parts. If you haven't already done so, I would recommend that you go back and listen to the introduction. It's also labeled Part 0. That'll help you understand what's about to happen. Alternatively, you can listen to the entire webinar as a single file. So without further ado, let's listen to this part. Let's have a look at jurisdiction. In dealing with cybersecurity, we inevitably get thrown into a multinational environment. That's because the internet enables unprecedented contact between people who are in different states. Now, having said that, states have an interest in applying their own laws for the benefit of their own residents and nationals. These 2 points lead to 3 legal topics that become incredibly important. The first is jurisdiction, scope of state authority, and that's the subject of this section of the knowledge area. Second is the subject of private international law, what lawyers also call conflict of law. And that answers the question, what state law or laws will apply when parties connected to different states are arguing with each other? Now, I have discussed private international law, but specifically within the context of individual rules. So Section 6, for example, talks a bit about private international law for contracts, 7 for torts, 8 for intellectual property, and 10 in the context of dematerialized documentation and trust services. Third, it triggers a question of public international law, the area that regulates actions among and between different states. So getting back down to just jurisdiction. Think of jurisdiction in 3 different categories: prescriptive, juridical, and enforcement. Now, in this knowledge area, I haven't spent very much time at all on juridical jurisdiction. It's a little bit too technical to get into. I have cited a couple of things you can look at. Mostly I'm talking about prescriptive and enforcement jurisdiction. Looking at prescriptive jurisdiction, we find that lawmakers routinely adopt laws that apply to people and activities that are outside the territory of their state. There's various theories that have been adopted to endorse this type of practice, the effects doctrine and some others that I don't get into terribly much, but as a practitioner, you just need to know that this happens. With respect to cybersecurity, some of the most common examples of prescriptive jurisdiction of activities outside territory would be laws that apply to offshore content that is visible inside the territory, offshore hackers who attack in-territory systems, or most significantly for many of you, offshore data controllers who process personal data that relates to in-territory data subjects, and of course there I'm talking about data protection and GDPR, which will come up later in this webinar. If we then look at enforcement jurisdiction, this is the area of jurisdiction where things get, well, a bit dramatic from time to time. Because here we're really talking about the police power of the state, the ability of the state to project its will over persons and property. So here are a variety of enforcement jurisdiction tools that are used. And I suppose if we were to further break these down, you could look at them as things that a state does within its own territory and things that a state will ask another state to do for it. So if we look at this in terms of asset seizure and forfeiture, for example, there we're talking about seizing domestic assets, which might be server infrastructure, or for that matter, it might be the seizure of a domain name when the domain name registrar is located in territory. In terms of what's located in territory, I've got some material in here about what we can think of as the location of a bank account, because even a dematerialized bank account eventually can be said to have a location. On the other hand, this next topic, foreign enforcement of domestic civil judgments, here's a circumstance where one state essentially asks another state to enforce a rule that a judge has issued. And here I'm talking only about non-criminal court actions. Foreign enforcement of domestic judgments is something that we really only talk about in the context of non-criminal actions. So if Alice in state A sues Bob in state B, and the State A court issues a judgment, then Alice might have to get on a plane and go to State B and ask State B court to enforce the judgment. When we talk about arresting people, though, that's normally something that happens when the person is present in the state. If the person is outside, well, that's where we look at extradition. We ask another state to extradite. Also, as an enforcement mechanism, as we get more technologically oriented, think about technological means to filter content on a geographic basis. Now, yes, there are some very dramatic statewide examples of a state mandating technological filters at the border, but there's also a lot of activity by content providers in terms of limiting how their content is distributed. Sometimes that's done for licensing purposes or to segment territory. Sometimes it's done as a compliance tool. So a lot of people who have material served up from their own systems will, of their own accord, try to filter access from certain states because they're trying to comply with those other states' laws or they don't want to get into difficulty with the other state. You can also get into orders addressed to domestic persons to produce data under their control wherever located, and of course that is a reference to the famous Microsoft case decided within the last few years about data stored in Ireland but under the control of people in the US. And finally, international legal assistance, and this is where the police of one state are asking for assistance from the police of another state in pursuing an investigation. Those types of enforcement points, particularly things like the Microsoft case, lead to a discussion of the data sovereignty problem. And I suppose the simplest statement is outlined here. The cloud provides a sense of location independence. Now, that's not the same thing as actual location independence. And we observe that states increasingly exercise enforcement jurisdiction based on the location of data infrastructure. That leads to the result that a large and growing number of states are imposing a wide variety of so-called data localization requirements. That appears to be the trend, and so I've written a bit about this as well. Let's turn briefly